We're going to get this thing started since you guys were prompt, and maybe some others will join us later. We'll do a couple introductions first. My name is Mark Hefner. I'm the landowner advisor for Braun and Gresham and Plateau Land and Wildlife Management. I'll be the moderator today, and we're going to have a really good time interaction-wise. Owning rural land can be complicated in Texas, and so there can be a wide range of issues. My role as the landowner advisor is to understand your issues and your goals and give you some advice, maybe even provide an expert that can help. So that's what I do here. Braun and Gresham is a law firm that represents rural landowners and that's their focus, is rural landowners and people that need some help. And they know how to deal with the unique issues such as rural real estate transactions, eminent domain cases becoming more of a concern, conservation strategies for legacy land and such like that. Our sister company, Plateau Land and Wildlife Management, assists landowners with wildlife management, implementation, and filings, ag filings. And they also have a team of biologists that can provide a host of information to help you better manage property. Today, the star of the show is Cassie Gresham. She's an attorney and counselor, and will be giving the presentation. Cassie and I have been working together for years with the sole purpose of helping landowners. We're going to be using an interactive approach today. So normally, if we had a large crowd, we may not be able to do this, but because we have a smaller crowd, we're going to open it up to where you're actually going to be able to communicate with us real time. So as Cassie's going through her presentation, she is very comfortable answering your questions. If you come across one right in the middle of the presentation, don't hesitate. If you do, we may miss it and come back to it later, but feel free to do it immediately. Also, you will have our contact information. So if you don't feel comfortable providing information in front of a group or they're recording, then feel free to connect with us later. Please don't hesitate. So again, on the recording front, we are going to record this. And so if you have confidential information or a sensitive subject that you don't want in front of a group, please feel free to reach out. You're going to have a way to get connected to all of us. And I believe that's it. I do want to start us off with a kind of just a warm-up question. And again, you're going to have to, and I need to make this point, you're going to have to unmute yourself. You now have access to be able to speak to us. So if you have, when I'm going to ask this question, you can answer if you choose to do so. I just would like to ask, is anybody on the call, do you currently own land that is either ag exempt or ag valued or in wildlife management perhaps? Okay, so we're going to assume that right now we may or may not have some folks that understand that. So I'm just going to give a real quick introduction to that. You may have property that has really low property taxes. It may be ag exempt or ag valued. Some of you may be familiar with wildlife management. If not, that's quite all right. We're going to move on. If throughout the presentation, again, Cassie mentioned something that spurs a thought, please don't hesitate to converse with us. We're going to have a great interaction. This is kind of unusual, but Cassie can handle this very well. So you guys feel free, open up, interact with us, and we'll get started. Cassie?
Well, welcome. Thank you, Mark, for that great introduction. And I look forward to chatting with all of y'all. We'll do a little bit of a presentation. I've got about 10 slides here that that will probably prompt a lot of questions. So feel free to interrupt me and let's talk about things that are on your mind. I know from some of the emails that a few of you may be realtors, so there may be questions that pop up that are more related to buying and selling rural land. So let's talk about those things because we can kind of help solve those problems too. So I'm going to share my screen here and start the presentation. We have, let me try to get it started. Okay. We have entitled this Common Property Tax Pitfalls. And these are really just issues that we've seen over the years in representing owners of rural land. Unfortunately, I'm seeing more and more of these as we get more and more new buyers into Texas land ownership, and as properties are being subdivided and sold, and even in COVID, the real estate market seems to be booming. So these are just some common things we see that that landowners need to make sure they're taken care of. So we're going to talk today about some common pitfalls. So failure to meet the requirements of the property tax code, failure to submit an application or annual report, failure to protest. We'll talk a lot about the appraisal review board process and how you work yourself through that. And then just kind of an overview of all the timelines, deadlines, your rights within the statute on an annual basis so that you kind of understand that context. And we actually have a handy dandy calendar that I'd be happy to send to anyone after the presentation if you're interested, that just highlights all of the deadlines that a landowner should know about every year. All right, so common pitfall number one, this is a failure to meet the requirements of the ag or wildlife statutes. So as Mark talked about, under the tax code, a landowner can qualify for a open space valuation, often called you'll hear it an ag exemption, is a colloquial term, but basically a landowner can qualify for a reduction in their taxes by either hosting or grazing or having ag on their property or doing wildlife management. And there's a definition in the tax code of qualified open space land, and it means land that's currently devoted principally to ag use. And then often questions we get is, well, what does it mean to principally use my property for ag? It really means that's the primary use, or any other use you're doing is secondary. So you can live on that property, you can have a homestead there, as long as you've got grazing animals or bees, or you've got a row crop or a hayfield, and you're using that property for agricultural use, then you can qualify for this special valuation. The second requirement under ag is that you use the property to the degree of intensity generally accepted in the area. And that is not very defined in the law, but over time, we've kind of developed what we think that means. That means how many animal units, how many animals does the appraisal district require? What is the standard with regard to each county? Each county may have a different standard, so I always tell the landowners that I work with, make sure you understand what your local appraisal district's requirements are and that you're meeting those. There may be a typical season for planting hay or planting a corn crop or those kind of things. And you also want to make sure that you are starting those practices, especially in your first year on January 1. Excuse me. Another type of open space valuation is a wildlife management valuation, and that is something that our sister company Plateau implements for landowners on their property. And you need a wildlife management plan for your property, and you need to do 3 wildlife management practices every year. And you need wildlife management to be the primary use of your property as well. And there are requirements within the tax code of how to do that. Under wildlife management, you must have what's called a qualified open space valuation in the year before. So that's ag or ecolab or timber, and if you're in East Texas, and that the principal use of the property is for wildlife. So again, you can have a residential use there where you're living on the property, but the surrounding acres is for wildlife management. A good example of that would be, I have a 30-acre piece of property and I have a wildlife management plan for it, and I'm living on the property, so I would carve out an acre, and that would be my residential homestead, but the remaining acreage around that property would be for wildlife management. Wildlife management activities are implemented year round, but there are seasonal adjustments. So you're going to do your brush clearing certain times of year. You're going to do the fire ant control certain times of year. If you're doing a census for birds, you're going to do that in the spring and the winter. So there's some guidelines that Texas Parks and Wildlife has about when to do those activities and which activities qualify. All right, any questions about that first pitfall? We'll kind of stop there and see. Basically, it's you want to make sure that that you're meeting the statute, that you're meeting the requirements, that you're have enough animal units, that you're doing the practices that the law requires you to do in order to qualify. And sometimes landowners don't understand what are the requirements of ag or what are the requirements for wildlife. All right, if we don't have any more questions, then I'll move to pitfall number 2. And this is the failure to submit. This comes up a lot when, because the common idea is that you have to resubmit, and well, the common idea is that well, once I have my ag or once I have my wildlife, then I'm good. I don't have to do anything to communicate with the appraisal district, and that's just not true. If you are purchasing a property and you're a new owner, then you have to resubmit your application to the appraisal district. If you move your property into a trust or establish an LLC for the property, if you add new owners, maybe there's a change in ownership where father and a mother deed a property or a portion of the property to the son and the daughter-in-law. Well, that's a change in ownership. Even though it doesn't feel like a big change because your family's still owning it, it requires you to resubmit. Sometimes the appraisal district also just divides their county into fourths, and they say, okay, this fourth of the county, we're going to ask to resubmit an application this year. They might also request an annual report. So this is more common with wildlife management, but they may say, well, we want to see everything you did in the last year, that your annual report, and we want you to submit that to us by the end of January of every year or the end of February of every year. And the appraisal district should send you notice about that you need to submit an annual report, but they don't always send you notice that you need to reapply. Some appraisal districts assume that you know the law and that you need to reapply if there's a change in ownership or there's a new buyer or there's something changing on your property. And in every case, the failure to submit an annual report or an application will result in a denial of wildlife management or ag or timber or ecolab. So if the appraisal district asks you to resubmit or there was a change in ownership and you didn't do it, and you fail to submit the application of the annual report, then it will result in the removal of your ag or wildlife management valuation. Anybody got any questions about that? I'll just tell you a story that I had of a client and how much they rely on their professionals. So I represented a client a few years ago that had a big property out on the Devil's River, and they purchased it from in 2007, and they had somebody managing it for them, and they did not realize that they lost their ag because no one told them that they needed to reapply in their own name for agricultural use. And they actually, when they got to me, it had been several years without any type of open space valuation, and they blamed their broker. In their mind, the broker should have told them that they needed to reapply. So a lot of people don't know what the requirements are, and it's our job as professionals to make sure that we're educating people about kind of what the requirements are and what the deadlines are, so they don't get stuck in a pinch.
Hey, Cassie, we did get one question kind of around this typed in. Is there any grace period if I forget to submit my ag application or annual report? or keep up my activities? Or do I lose my valuation immediately and can I get it back?
Yeah, so there is a deadline. So the deadline to submit an application every year is April 30th, and it's a statutory across the state deadline. So every appraisal district may have a different deadline for annual reports. They may be the April 30th, depending on the appraisal district, but that is the statutory deadline for submission of applications. You can submit a late application to the appraisal district as long as you're doing it before the rolls are certified, and that's kind of what the tax code says is the rule. And most of us are like, well, how do I know when the rolls are certified? And again, that depends on each appraisal district, but a good rule of thumb is usually if you do it before July 15th, mid to end of July, then you will have met that deadline. You just pay a 10% penalty for the late application submission. If you don't keep up with your activities, then you can lose your valuation. There are ways we can help you. I've had clients, they did the activities, but maybe they didn't put them in a format in which the appraisal district wanted to see. There wasn't a map included, or there wasn't enough detail. So we've partnered with Plateau to help with wildlife management annual reports to get those submitted in a fashion in which has enough detail. And we know, and Plateau knows, the questions to ask the landowner that the landowner will say, oh yeah, I did that. I just didn't know that the appraisal district cared about that. So we can sometimes put it in a way that helps you. And how you get it back is really, we're going to talk about the protest process. How do you negotiate that, and what's the steps if you actually lose the valuation.
Thanks, Cassie.
Right. Pitfall number 3: failure to protest. All right, so this is it's my annual report got denied, my application got denied, and I didn't realize it, and I failed to protest. And this is one of the biggest pitfalls that you can have. For instance, I was working with a little old lady last year, and she had plans to sell her property. So when she got notice and she already had a contract on it. And when she got notice from the appraisal district that her ag was being removed because she failed to submit an application that they had requested from her, she just ignored it. And so they removed her ag valuation, and she didn't protest the removal because she was like, well, it's no longer my problem. I'm going to close on this property, and it's going to go to the seller, and they'll handle it. And she didn't realize that by failing to protest, when the property didn't close, that she put herself in a bind. So when she saw that denial letter, then she should have protested, just as a precaution, and also just as a safety net. So one thing we do is when we submit applications on behalf of landowners, we go ahead and file a protest if we have not received approval within by May 15th. So there's 3 kind of opportunities to protest. There is the May 15th statutory deadline that says if you want to submit a protest on market value or ag or wildlife, you're going to make sure that you submit that by May 15th. You also have an opportunity to protest 30 days from your denial letter. So let's say you get the denial letter on March 30th, then you need to protest by April 30th. I think that the tax code reads May 15th or a date that's later, whichever is later. But I did have an appraisal district, Travis County, last year where they sent a denial letter, and my client failed to protest within 30 days of the denial letter, but did protest by May 15th, which is the statutory deadline, and Travis County claimed we didn't protest on time. I think they're completely wrong about that with regard to the law, and I think you actually have on a protest maybe a couple of different bites at the apple. You're also going to get a notice of appraised value every spring that's going to come to you, and if you're not receiving that, you should be calling the appraisal district and asking for it. So about this time of year, March, April, early May at the latest, you should be getting a notice of appraised value, and that's the notice that shows you how much is the market value of the property. Did you receive an ag valuation? It's kind of the appraisal of the property altogether. So when you get that notice, I've been talking a lot about ag and wildlife, but this also applies to market value cases. You need to protest 30 days from the notice of appraised value or May 15th to say, hey, I don't think my market value is accurate, because that's your time. And you do have an opportunity. You can file a late protest. So if you miss any one of these three timelines, you can file a late protest, but you have to prove to the Appraisal Review Board that there was good cause for your late protest. And the only time I've been doing this work for almost 17 years, the only time I've ever seen an appraisal district grant a good cause was because a landowner could prove that the appraisal district sent it to the wrong address. But if you say, hey, I didn't get the notice, I didn't know that I needed to protest, that's not considered good cause by most appraisal review boards. And the law is really stacked against landowners and homeowners with regard to what their rights are in the protest process. So you want to make sure you're following the deadline, because it gets really hard if you miss that protest deadline and you file a late protest, what your options are at that point. But we're gonna talk about that. Is there any questions about that particular pitfall? All right, I'm going to move on to the next one. So common pitfall number 4 is not working well through the ARB process. And so the Appraisal Review Board is a group of landowners or homeowners that are appointed by the chief appraiser. There can be 3 to 5 of them, and they serve on a little board. So when you file your protest of your denial of ag or wildlife, or you're arguing about your market value, then your protest actually goes to this board called the Appraisal Review Board. Every appraisal district has one, and you are entitled to a hearing before those homeowners or landowners. And they will notice you for a hearing that you can come and present your evidence about why you think your denial was wrong, or why your house should not be appraised for the amount of money that the appraisal district has appraised it for. Or, hey, and you've appraised my house as the same as my neighbors, and I know my neighbors, have a nicer house than mine. I know mine has foundation issues, and I don't have the really nice granite countertops that my neighbor has, and all of those things. So once you filed a protest, you're entitled to a hearing before this Appraisal Review Board, and you're actually allowed, they're going to send you a notice of, hey, show up at this date and time. And you're allowed as a landowner to reschedule once. So you can contact them and say, hey, I'm going to be out of town, I've got a doctor's appointment. You're allowed any good cause for the hearing to be rescheduled, but only once. I often tell landowners, once you file your protest, if you have not heard from the appraisal district about your hearing within a couple of weeks, then I would definitely encourage you to check in. There is usually a person working for the appraisal review board that's schedules all the hearings. It is not uncommon that you may file your protest in May and you may get your hearing in September, especially in bigger counties like Williamson or Travis, or, I mean, especially the last year in COVID, we've had very delayed schedules on hearings. But you want to make sure that they received your protest and that you're in the queue to get a hearing. You can actually request the evidence that the appraisal district is going to present at least 14 days before the hearing. So if you get a notice, then you can send the appraisal district a request to say, well, I want to see all the comps that you're going to have for my market value, for the market value appraisal of my house, and they're entitled to send you all the data. Or if you had an ag denial or a wildlife management denial, asking them for the reasons of their denial, what's the packet that they're going to use or the law that they're going to use to prove to the ARB. And you're entitled to that 14 days before. That's a statutory deadline. So sometimes I've used that as a way to postpone the hearing or to get a new hearing date, because they're required to provide that at least 14 days before. And you should bring your own evidence to the hearing. So it is your opportunity to convince this panel that that you're right and the appraisal district has the market value of your house wrong. I would encourage you to be respectful yet forceful, professional, and stating your case. And it's really, I've got a case right now with a client that we're in a lawsuit with, where the appraisal district is saying, well, your lawsuit is not valid because although you had a hearing on two different parcel ID numbers, two different property ID numbers, and you protested that, and we can see from the notes that were written by the ARB members that we talked about those issues, but the order that was issued by the ARB was erroneous and didn't include both property ID numbers. So there are all kinds of gotcha games with regard to how the appraisal review board operates in the appraisal district. And we're now fighting with them because they're trying to throw our lawsuit out to say, well, we did our part, y'all didn't do your part. So I've been in hearings before where we've had multiple issues. So if you're handling that hearing as a landowner, you want to make sure that you're getting an order from them addressing all of the issues that you're raising. So if you're raising a market value issue about two different parcels, then you want to make sure you're getting an order on those issues and be really precise, because they can mess up their process. And if you're not getting out of it what you need to fully address your what's happening, then you won't be able to file a lawsuit. Any questions about this process? I'll also say that landowners I find this process, the ARB process, very frustrating. Most landowners find this process super frustrating because it is like if you're going in and expecting a judge and a jury type atmosphere, it is very much not like that. It is run by a chairman. They make lots of mistakes. They talk amongst each other. It can feel like the appraisal district just throws in the kitchen sink, and they do. So it's really important to kind of understand the process and what you're going after and be very clear in your communications. They do record them, and so it's good to go back and listen to it to make sure that you've gotten what you need. But I've actually had to correct them in an ARB before of, no, you didn't do the process right, because I knew a lawsuit was coming, and I needed to make sure that it was procedurally done correctly. And just keep in mind that although they will tell you at the very beginning that we're totally independent and we're different from the appraisal district, they are going to see you once, and they've seen that appraisal district staff dozens, if not hundreds of times before them. And so as far as the trust level, they're going to give more credence to the appraisal district's arguments a lot of times because they're used to seeing them, they're friends with them, they're drinking out of the same water cooler. And that can be a little frustrating from the landowner perspective. One of the other things is, landowners can file a late protest. You can only get, like I said, a good cause. There are, especially on the market value side, there are, and I can get into more details if you had questions about this. It's kind of complicated, but there are things under the tax code that allow a late protest for certain issues, and those would be ownership changes, or if you're arguing about a pretty big increase in your taxes, but you have to file those protests before your taxes are due, which are January 31st of every year. So let me give you an example. I had a landowner last year that never got their notice that their notice of appraised value, and they didn't receive their tax bill. And they realized when they got a delinquent tax notice that, oh gosh, I never got my tax bill to pay it. And the appraisal district was sending it to the wrong one. And they never got the opportunity to protest. So we can file a late protest in that point. But if they've missed the deadline to pay their taxes and they're delinquent, then the first thing, I can get them a hearing, but the first thing that the appraisal review board is going to ask when we walk in is, were you late in paying your taxes? Because it will kick out your protest or your lawsuit or whatever you're doing if you aren't paid in full. And I had a hearing recently where I had a landowner who did not receive notice of their ag removal or their wildlife management removal until after the fact, and we filed a late protest. And the appraisal district kind of admitted that they were wrong, and she didn't get notice, and we could tell it was the wrong address. She was totally in the right, and we go to a hearing almost a year later after she protested, because it was during COVID and it took a really long time. And the first question they asked the appraisal district is, look up on her in the database, and did she pay her taxes on time? And luckily they could see that she did, but she had only paid the ag portion. So we had a fight at the appraisal review board hearing about whether or not that was sufficient, and whether or not those were delinquent. And so there just can be, they will try to kick out any protest that you have if you haven't paid your taxes. I covered a lot of this. You need to make sure you get an order. You need to follow up with the appraisal review board to get an order. And that if you decide to file a lawsuit, you should do that within 60 days of receiving the order. And I always tell landowners, the decision to file a lawsuit or not to file a lawsuit is really a business decision. It depends on how much you would save and what the cost of the litigation might be and what your chances are of settling it. 99% of our cases that we file against appraisal districts do settle, and we are able to work those out. All right, any questions on the pitfall number 4? All right, I'm going to move on to pitfall number 5. This is just kind of understanding the tax code calendar and all the little nuances of it. So we're going to just go through this. You should always keep in mind as landowners or homeowners that the appraisal process and the processing period is kind of January to May. So January 1, were you in your house? Was it constructed? If you own a piece of land, did you purchase it by January 1? How were you using it for ag and wildlife? And so sometimes with appraisal districts, they will send out requests during this period for landowners to submit annual reports, and that is appraisal district specific. but typically a notice of appraised value is sent out about April 1st. Again, remember, you've got 30 days if there's a problem with that notice of appraised value. So if your market value is wrong, or you don't see that you have an ag or wildlife management valuation, that's when you would protest 30 days from that. April 30th is the deadline for any exemptions or special appraisals, so ag, wildlife, timber. So the April 1st is the notice of appraised value for single family residences, and then May 1st, and these are just kind of good rules of thumbs, notice of appraised value for all the other properties, so ag and wildlife properties. May 15th, again, is that protest deadline, or the 30th day after the notice is filed. So let's say your notice comes out May 17th, and you realize, oh, I just got this in the mail, I've already missed the May 15th deadline. You still have 30 days from that date to protest. And then the protest and challenge period is July, sorry. You're going to file any protests that you have. You know, if I haven't heard from the appraisal district on behalf of a client, I'll just put in I think of protests as a placeholder, because you can always remove them or not show up to a hearing. But you want to make sure you're communicating with the appraisal district and know if there are any problems. So May 15th is kind of the statutory deadline. We're just giving an estimate here. Usually about mid to late July is when the tax rolls are going to be certified. Every appraisal district is different. It could be July 22nd in Travis County, or it could be July 24th in Williamson. But the comptroller really wants them to get those rolls certified by August 1, which means the majority of their tax rolls have been resolved in the protest. The bigger appraisal districts have a harder time with that. And so, you can file a late application, and there's a 10% penalty on that. One thing to note too is you can always file a homestead application and have it go retroactive back for 2 years. So it's a good thing to know that you can do that at any time during the year. And really, the appraisal district spends their time July through October kind of assessing property and for the following year, right? So it seems a little weird. So when you get that tax bill in October of every year, it's for this past period of assessment, and you pay it by January, at the end of January for the previous year, because it gives you an opportunity to protest. So again, this is the collections period, October to January. Sometimes you don't notice that something's wrong with your taxes until you get your bill, and I've had clients do that. So usually October, you're going to receive the bill, and the tax are due in January. We can fix problems if you receive it in your tax bill, but it's before that January 31st deadline. It gets more difficult if it's after the January 31st deadline. And here's our handy dandy property tax calendar that we have given out to our clients. And it just goes through a lot of those dates and reminds it. And so if you'd like a copy of this, please email me. My email address is cgresham, CGRESHAM @braungresham.com. And I'll be happy to send this to you. You can put it on the idea behind this was that we provide these to landowners and homeowners, and they could put it up on their refrigerator as a reminder of things to be looking for. Right?
Hey, Cassie.
Yeah.
A lot of the questions I get sometimes around those letters from the appraisal districts, it will say on that letter, here's your notice of appraised value, or you need to apply for your ag valuation. And then it'll say 30 days from the date of the letter. So at the top, it'll have a date on it. Is it from the date of that letter, or the date the landowner receives it? And then it sounds like, if I understand you correctly, even if that's missed, they still have until May 15th. Did I just summarize that correct?
Yeah, I always tell landowners I use the date of the letter if
Okay,
possible because there's no way to prove when you received it. So
right,
most of those letters don't come
on the same day.
certified mail and they don't come the same day. I do think the statute says 30 days from the date you receive it, but it's hard to, unless you have a law firm like we do that track when that is coming in. And we date stamp those. Most lenders are not going to do that. So a good rule of thumb is just to base it because you got a date at the top. It was 30. You're well within that window. And I do believe, although I've had appraisal districts argue with me, I do believe that May 15th is an additional opportunity.
Okay,
Let's say you, like the example I used before, you got your notice of appraised value March 15th and you didn't protest it by April 15th. I still think statutorily you have the opportunity by May 15th to do that.
okay. Good information. And real quick, I wanted to clarify to the attendees, if you don't feel comfortable actually speaking, you can go ahead and go to the bottom and look at the Q&A or the chat. You can send us a question that way too, but I'll turn it back over to Cassie.
Yeah, I'm happy to answer any questions or also my email address. Feel free to email me with any questions that you may have or I can always set up a call to talk with anyone. I know sometimes you don't want to share about certain situations that are going on, but we want to be a resource for people. So I work a lot with other professionals. I often get questions from the ag extension, or I think we did a podcast a year or so ago with them and just about property tax issues. So I'm always happy to answer and educate and make sure that people kind of understand their rights, because I do feel like that it can be really hard for landowners. And I spend a lot of my time on this summer fixing problems that if we would have known or had better communication with the appraisal district, we wouldn't have had the same issue. So if the one takeaway I think that I would have for people is that, overly communicating with your appraisal district, making sure that you really are involved and understand and you're, if you have an ag and wildlife management valuation, picking up the phone and calling that local ag appraiser and knowing them on a first name basis and saying, what do I need to be doing? Is there any, what's the deadlines for this county? Those kind of things are really helpful. Plateau does a great job of, and Braun and Gresham too, of when we get notice, when we get something from the appraisal district that is a heads up to landowners across the county, we will make sure that our landowners are aware of that. But sometimes we don't know, just like landowners don't, what their requirements are. So it's really important that you're checking in and that you're thinking about it in this springtime time frame. You're thinking, oh, is there anything I missed? Do I need to check in with the appraisal district? Have I done everything I needed to do this year? This is a good time to kind of like tax season, have that like on your radar about property taxes as well in the spring.
Absolutely. Do we have our contact information on one of the slides?
Yeah, let me see.
I think so.
Let me close out this.
While we're wrapping up, we can.
Maybe. There, hold on. That's our landowner alert. That's the contact information.
There you go.
It has mine and Mark's contact
Absolutely.
information there.
And Cassie, I'm just going to jump in here. This is Avalon. I do see that a couple of our attendees raised their hand. If you're having trouble unmuting yourself, you should just be able to scroll over your Zoom screen, and then there's a toolbar that pops up at either the top or the bottom of the screen. And on that toolbar, you should see a little microphone, which you can click to mute or unmute yourself. And then there's also that Q&A option, which if you click that, that actually opens up a separate pop-up box and you can type your questions directly in. If there are no questions, yeah, of course, Mark. If there are no questions for today, then I'll go ahead and I have this recording. I'll share that with y'all and we can certainly follow up.
Well, I wanted to give everybody an opportunity if they were typing in something or had a. I don't see that anybody's unmuting themselves, so. Well, again, it was a pleasure to talk about these issues and the common pitfalls for landowners, and happy. I'm always here to advise or help if you have any landowners you're working with, or you personally have any questions. Happy to engage and help you out any way I can.
That sounds good. And I just want to remind everybody again, if you weren't able to ask the questions, please don't feel like we're not going to answer. Cassie or I or any of the group can help out. So you've got phone numbers and emails. Please don't hesitate. Cassie, thank you for taking the time out to educate us.
Yeah, it was great. Thanks so much.
Thanks, everyone.
Bye-bye.